has the Liberal government always known that it was illegal to prohibit our hunting and sporting firearms through the use of their Order and Council powers? Let's have a look. Welcome back to the channel. So today we're going to be making the case that the government has always known that their gun-ban Order and Councils, the OICs, were against the law. For those who have been following my CCFR vs. Canada series, you know that this is one of the issues which was brought forth by our side. The CCFR and friends claim that the 2020 Order and Council was ultra vires, which is to say that it was outside of the scope of the government's authority to use the Order and Council power to ban the firearms that they did. Because the Order and Council powers found in Section 117.15 of the Criminal Code prohibit the banning of hunting and sporting firearms. Now, unfortunately, we've had both the Federal Court and the Federal Court of Appeal dismiss our claims, and now we're seeking leave to appeal these rulings at the Supreme Court of Canada. But here's the thing. Not only is this something that our side clearly believes, but I think you could make the case that the government has also always believed that the Order and Councils were ultra vires as well. Now, we've got two disclaimers in this video. First off, as always, I am not a lawyer. Nothing in this video or on this channel should be taken as legal advice. Secondly, and more importantly, this video is going to be a bit more speculative than I would like. Because normally I try to speak in black and white facts and back up my claims or my statements with as much evidence as possible, but that's not really going to be so easy to do in this particular instance. I'm still going to be painting you a plausible picture of the situation at hand, but at best, this really shouldn't be considered anything more than circumstantial evidence. With that out of the way, this story comes down mostly to timing. When you look at the various gun control regulations and legislation since 2020, they were brought in at rather convenient times to say the least. Most people have been of the mind that these were brought in for election purposes, and there's certainly enough evidence to back up that claim. But there's another version of this story which still adds up just as well, that no one has really talked about. So back on May 1st, 2020, the government released an Order and Council prohibiting over 1,500 models of hunting and sporting firearms, which they had then rebranded as assault-style firearms, often going so far as to directly call them military-grade assault weapons. As a result of this, a court challenge for judicial review of these regulations was almost immediately launched by several interested parties in Canada. Among others, the CCFR has played and continues to play a vital role in the case, and the NFA also provided some financial backing for Solomon Friedman and the Parker applicants at the federal court level. So right out of the gate, our community's heavy hitters lined up and just came out swinging. However, it took nearly 3 years before it even got before Justice Kane at the federal court. And during that time, the Trudeau government was not exactly idle. Yet simultaneously, they also didn't promulgate any new ban lists through their Order and Council. They promised they were done. They swore no more gun bans were coming. They were satisfied with their prohibitions and that these prohibitions were okay because firearms like the AR-15 were not necessary for hunting and sport because there was the availability of alternatives. And for years, this was actually mostly true. Despite the fact that many of the most popular semi-automatic firearms like AR-15s and MCXs and so on were prohibited, there were still other available firearms which were mostly the same. Firearms like the DeVores, the AR-180Bs, and so on. But that didn't last long. The spring of 2022 came around, and on May 30th, 2022, the Trudeau Liberals announced their now infamous handgun freeze legislation, Bill C-21. It went through its first and second readings and then on to committee in SECU. Now, during this time, the handgun freeze was brought in early by yet another Order and Council, rather than waiting for the bill to come to its natural resolution. And then, just as committee discussions on C-21 were coming to an end, the Liberals randomly and very suddenly introduced 46 new amendments to C-21 on November 17th, not the least of which were Amendments G4 and G46. The Liberals were banking on their unofficial coalition majority with the NDP to carry these amendments through committee without any discussion. However, thanks to the campaigning of various members of the firearms community and a surprising amount of backbone from NDP Member of Parliament Alistair Macgregor, the Liberals were forced to drop many of these amendments, including G46, and then change the evergreen definition found in G4. For those who may not remember, G4 was the birth of the evergreen definition, which did eventually find its way into the final version of C-21, and it is currently law. However, the original wording found in G4 was slightly different than what ended up eventually being signed into law. Originally, the definition would have prohibited basically all semi-automatic firearms in Canada, like all of them. However, the version that was passed into law now only prohibits the new models manufactured after December 15th, 2023, or requires these new models to use proprietary magazines. G4 also attempted to sign into law the other Order in Council restrictions relating to bore diameter and muzzle energy, but those never actually made it into the criminal code. And then G46 was essentially the ban list itself, but not just the original 2020 ban list either. It was also expanded rather significantly to include most of the firearms which were later banned in 2024 and 2025 in the second and third ban lists. It also tried to enshrine into law most of the previously prohibited firearms and other weapons found on the prohibited weapons list going back to 1998, including things even like tasers. Now, at the end of the day, it did end up failing, and the amendment needed to be withdrawn on February 3rd, 2023, mostly due to one reason. G46 also attempted to ban the SKS. Now, this is pretty relevant for today's discussion, as the SKS is once again back on the chopping block, with the government again embroiled in the discussion on banning the SKS as a result of groups like Police Soviet making very vocal and renewed calls for its prohibition. We'll come back to the SKS again before the end of this video, but here's the question. The Liberals knew what they wanted to ban and had an official list formulated as early as November of 2022. Yet despite that, they waited until December of 2024 and even March of 2025 before officially prohibiting these firearms. So why the wait? After all, even if they couldn't manage to pass these new ban lists into law with C-21, they could have pulled the trigger literally at basically any point and made these firearms prohibited through an order in council at essentially any time. And that even goes for the SKS as well, which is still currently legal. Like, we know the government wants to ban it. So what are they waiting for? Now, the obvious answer here that everyone goes to is election season. The Liberals need some form of gun control to campaign on in order to scare Canadians into voting for them. So the longer that they can stretch out this persecution of gun owners, the more that they can benefit from it. And, fair enough. That explanation is simple enough and it makes enough sense. Like I said at the beginning of the video, there is certainly enough evidence for all of that. However, there is a different explanation which I think is a better fit. G4 and G46 were kind of random and totally out of left field. In a bill about so-called red and yellow flag laws and a handgun transfer freeze, amendments related to the mass prohibition of firearms, of long guns, rifles, and shotguns, that was wildly and clearly out of scope and normally wouldn't have been allowed, especially so late in the process. But of course, the Liberal chair of the SECU committee was all too happy to allow it anyway.
So we were not provided an opportunity to debate this at all. So you ruled on something where I had barely made the case for why this is out of scope. Mr. Lloyd's made a good point. So you're not providing us ample opportunity to say at all. There's a number of other things to consider that this is out of scope. So how can committee members vote if they have not been fully informed of the possible implications of this? I'm just not clear why we weren't provided more time.
Well, the decision of the chair is not debatable. The decision of whether to override the decision of the chair is also not debatable.
But we haven't not been able to say our piece of whether we feel it's in order or not. So are you going to go through every single one and without us even getting the opportunity as Conservatives, NDP, and Bloc to say why we may feel this is out of order and out of the scope, you're going to just cut off that debate, Mr. Chair? Is that what we're understanding?
It's not a debatable question.
But you, as Mr. Lloyd said, you decided this was in order before we even were provided an opportunity to say why we believe that it isn't. So you're setting now the standard that no one at this committee can argue for any of these amendments that we believe they're not in order. Is that what I'm understanding is happening here? We can't say our piece of why we think this is out of order because you jumped the gun in essence and said that this is in order and I say so. I'm just being clear on what your position is on this. Because there are this many amendments.
And this whole action was even publicly labeled as an abusive process by the NDP, who were essentially their allies at this time.
Since C-21 was first introduced on May the 30th, our understanding of the bill was that it covered three main areas. It was a handgun freeze, it covered a new proposed red flag regime, and also covered airsoft. And for this amendment, this very substantial amendment to drop on our lap at the 11th hour is an abusive process, in my opinion.
Now, to be clear here, Macgregor was not against the content of these amendments exactly. He was merely against how they were introduced. And all of this led to many in our community being so angry at what the Liberals were doing, we didn't exactly stop and take a hard look at why they were doing it. Because all along, the Liberals were insisting that they needed to enshrine these amendments into legislation in order to prevent future governments from easily reversing the Order in Council. Now, I don't mean to scare anyone, but here's the thing. Future governments can't actually reverse these gun ban OICs simply by using another OIC. If the Conservatives win a possible spring election here, if there's one to be had, they can't just OIC our firearms back down to restricted or non-restricted status. That power doesn't exist anymore. It was repealed by C-71 back in 2019 by the Liberals. The power to lower a firearms classification through an Order in Council was still on the books back when the Liberals were making these claims during C-21, but its repealment had already received royal assent in 2019, and it was waiting to come into force, which happened 4 years later, alongside C-21 in 2023. What this all means is that in order for our firearms to return to their original classification statuses, Conservatives either need legislation to return that power to the OIC abilities, or to enact new legislation which directly changes the firearms classification. Now, for anyone freaking out, there are still other options to a possibly newly formed Conservative government, such as amending the terms of the amnesty to permit use and extending it indefinitely, but we're in for a longer battle if we want to fix a lot of the mess that the Liberals have caused for our community. So what this all means is that the Liberals already knew that future governments weren't going to be able to simply undo their OICs with another OIC. And they already enacted the changes needed to close that door for us. What they were actually doing was just sitting on the coming into force period to lend authenticity to their otherwise illegitimate claim. So if the Liberals were already fully aware that no future government could reverse the Order in Council, then why the sudden and irrational urge to push through an abusive process to have the ban lists enshrined into law? Well, because there is another entity in Canada which does actually have the power to reverse the Order in Council if it remained merely regulation. And that entity is the court. If the government loses a Veery's claim at court, the typical remedy is that that regulation is struck down by the court. So if the CCFR was able to win at court on the Veery's issue, it's quite likely that the gun bans would have been reversed. Not only is that really bad for the Liberal ideology, but it's also extremely bad optics politically. Having the court say that you've gone too far and that you're outside the boundaries of the law in your unjustified persecution of a minority group is just not a good look. And such a thing could have maybe even toppled the already unpopular government at that time. So if you look at the timing of G4 and G46, that'll happen in November of 2022. If Alistair Macgregor had simply nodded his head and just went along with whatever garbage the Liberals wanted at committee, and if the Senate didn't take ages getting through its readings, which only took a few months anyway, it's not an unrealistic time frame to put C-21's royal assent in the middle of, late spring or early summer of 2023. And you know what else was happening at exactly that time in 2023? The CCFR's court case at the federal court with Injustice Kane. Had G4 and G46 received royal assent by that point, or even if it was still in the late Senate stages, the government's lawyers would have had another legal option open to them at court. They could have argued for something called mootness. So what is mootness, you might ask? Well, a moot point is like a cow's opinion. It just doesn't matter. It's moot. Friendly banter aside, mootness is essentially the idea that whether or not you're right or wrong, or whether you can win your case or not, it doesn't really matter because it's not going to change anything. So the court doesn't have to hear you out or rule on your questions because it'll have no practical effect or outcome. If, for example, the ban list had been enshrined into legislation, then our question of whether or not the government adhered to its restrictions set out in Section 117.15 subsection 2 of the Criminal Code, that question just doesn't matter anymore. The government isn't supposed to be able to ban hunting and sporting firearms through the Order in Council power, but they absolutely can do it through an enactment of Parliament. Or at the very least, the restriction that's found in the Criminal Code, that doesn't apply to the legislative process in the same way that it does apply to the Order in Council. So even if the courts cared to side with our case, our arguments simply would have been trumped by the list actually being solidified into parliamentary legislation whenever that legislation was passed. So for me, I think that's why the government did what they did when they did it. It's likely that after all the information came out and all the affidavits and cross-examinations were completed, the government's lawyers noticed how squirrely their case was getting, and they were no longer confident that they could win on the merits of their case alone. So they were attempting to win by gaming the system with a last-minute legislative change, which could have more or less invalidated a lot of the CCFR's case, particularly the ultra vires issue. And it made sense to hold off on this as long as possible so that the applicants could waste as much of their limited resources and morale as possible, so as to weaken our community even further. And a court-centric focus for the timing of these ordering councils also better explains the 2-year delay between G46 and the second and third ban lists. Like, things were already looking pretty shaky for the Trudeau government back in late 2024, and they could have been brought down at literally any time if Jagmeet had found some backbone. Their coalition was long over at that point, and despite the precarious situation that he was in, Trudeau waited and didn't bring in the second ban list until December 5th, 2024. If the timing here really was election-focused, he should have done it much sooner, especially considering that he had already made the ban list for G46. It's not like they were busy trying to figure out what to ban. Like, they knew what they were after years before that. So if an election was their primary consideration, stalling and waiting as long as they did was fairly risky, with minimal benefit. However, the second and third ban lists were made within months of each other and timed perfectly to coincide with the CCFR's return to the Federal Court of Appeal on December 9th and 10th. By waiting several years to drop these lists, even after publicly promising many times that they were absolutely done banning firearms, they were able to dodge the court's scrutiny of these 2 new lists. And why is that important? Well, because ban list 2, and especially ban list number 3, they do not adhere to the reasoning found within the original order in council. Originally, they said they were only banning modern firearms or those which were present in large volumes in the Canadian market. That wasn't especially true of the first ban list either, but it's especially untrue of the second and third ban lists. And many of those newly prohibited firearms were collector items, or firearms dating back even to the Second or the First World Wars.
Any of the firearms that are on that list do have legitimate purposes, primarily in sport shooting. Some of them are also used for predator control, for hunting, and I'm talking about things that have not something new. Some of these they're talking about banning firearms that are 100 years old. And, well, they're not talking about it, they have done it. So some of these things are historic museum pieces. There's certainly nothing that any stretch of the imagination could be classified as assault style, whatever that is supposed to mean.
They also said that firearms like the AR-15 were unnecessary for hunting or sporting purposes because there were alternatives available. But these new ban lists now have banned all of those alternatives as well, meaning that even though necessity is not the test, the new OICs contradict even the Liberals' own flawed logic. This has directly led to the death of a number of shooting sports in Canada. And this reasoning that ban lists 2 and 3 contradict is the backbone justification for the Liberals' gun bans in the first place. Without it, the government's case falls apart. And if they enact new order in councils in contradiction to this reasoning like they did in ban lists 2 and 3, that also hurts the government's case much more than it helps. But none of that becomes an issue if it never actually gets to have its day in court. So I think they waited until the last possible minute so that these new order in councils wouldn't have been questionable in the Federal Court of Appeal. They will be highly relevant and could even sink the government's case at the Supreme Court if the CCFR and friends can get there, but the Supreme Court only hears less than 10% of their applications anyway, so the odds really aren't great for us there. And given the traditional bias against us gun owners, the Supreme Court might just refuse to hear our case anyway in order to avoid the controversy, since they don't have to disclose reasons for why they refuse to hear an application. Like, the Supreme Court only hears cases of national importance, but there really hasn't been a more controversial and questionable use of the government's powers in recent history in Canada. And the result of these regulations have hundreds of thousands, if not millions, of otherwise innocent Canadians facing criminal liability, which is justified only by political ideology. Like, if that's not a case of national importance, then nothing is. Despite the statistically low odds of being accepted to the Supreme Court, I think it'd still be highly suspect if the Supreme Court doesn't want to hear us out when the consequences of not doing so are so incredibly high for our minority group. So maybe this distinction isn't all that important, and maybe I'm just splitting hairs here, but the timing and the rollout of these bans and confiscation appear to be more related to gaming the courts and the legal system rather than just being simply an election tactic. This would indicate to me that the government knows full well that their gun bans couldn't win on its own merits, and that they're fully aware that their gun bans are probably against the law.
Have I been living with him for too long, or did that all just make sense?
I don't know. It's an idea anyway. The official nationwide rollout of the confiscation program is expected before the end of the year, likely in the next week or two, once again coinciding with yet another anniversary of Polytechnique. Like, it really feels like there needs to be some kind of statute of limitations or something on these tragedies so that I can't be annually persecuted on behalf of the actions of someone I don't agree with who did something horrible before I was even born. But that aside, there has been a lot of talk and a lot of push from Police Souvient, particularly Heidi Rathjen, for the banning of the SKS. And I gotta be honest, I don't see that actually happening. But at the same time, it'll be a good measure to see if I'm right about their motivation. Because we still haven't heard back from the Supreme Court as to whether or not they want to hear the CCFR's case. Because if the Supreme Court decides to hear the case and there is a new order in council on the books which bans the SKS, then I think it's game over for the gun bans. Because the Liberals are on record stating very clearly that the SKS is absolutely reasonable and suitable for hunting for civilian use, despite its interchangeable status as either an assault-style firearm or an assault weapon. So from where I'm sitting, there's just no amount of mental or legal gymnastics that a court can entertain to get away from statements like that. So if the government postpones the banning of the SKS until after we hear back from the Supreme Court, that speaks to their motivations well enough. And we should know if we're going to the Supreme Court in the next month or two, but the government has also clearly bitten off a lot more than they can chew with the confiscation program as it is. Adding the SKS to the ban list would be a whole other nightmare that they simply can't deal with. Frankly, if they do it, they'd probably just be doing it to spite our community at this point. But ultimately, there is little sense in speculating on what they may or may not do until they go ahead and do it. Because there have also been rumors going around that new prohibitions might be on the horizon at some point as well, for things like optics and bipods and muzzle devices and so on. But again, if the government uses the OIC powers to ban these before the Supreme Court makes their decisions, then I think that hurts the Liberals' case more than it helps, even if the ultimate goal here is to use the mass criminalization of our minority group to win elections. All that being said, I'd like to thank you all for watching, and we'll see you in the next video.